Hello, everyone. My name is Roshan Akbasiri Garb. I'm a partner in the corporate team of Clyde & Co, and I'm based in the UAE. I am joined today by my colleague, Rebecca Hilton, and she's one of our best knowledge lawyers in the region. So as part of our Middle East and Africa regional series, we are exploring the developments shaping the business, investments, and regulatory environments across the region by taking into account the present regional and global context.
Hi, everyone. So today, Roshanak and I would like to focus on another important aspect of the evolving company law landscape of the UAE, which is corporate governance.
And well, Rebecca, everyone that knows us too know that this is a topic that we are both very passionate about. Also because it has got a long history of evolution in the region. So over the last decade, we have definitely seen a real shift towards stronger governance standards, starting with the 2015 Companies Law. And what's important for clients is understand how those early rules have developed and continue to evolve and can be used to strengthen business resilience and continuity at times that, as we know, require adaptation and strategic pivoting too. It's a bit like what we see, right, as positive impact that a strong, stable, and calm leadership can have in uncertain times.
Oh, exactly. So we'll walk through some of the key milestones. So how governance first appeared really in the 2015 Commercial Companies Law, how the UAE Capital Market Authority has developed and continuously updated its corporate governance code for public listed companies in the UAE, what the rules are for private companies like onshore LLCs, and how the law deals with issues like board continuity and deadlock situations. We'll finish by looking ahead at where governance in the UAE might be heading next with some practical examples along the way. So Rosh, let's start by going back to 2015 with the first major reiteration of the UAE Companies Law since way back in 1984. What did the 2015 law have to say about corporate governance?
Well, I mean, first of all, we were 10 years younger, so definitely a good time to think. Yes, indeed. So, but yeah, the 2015 Companies Law introduced something quite relevant for corporate governance because that was definitely the first big step where the concept of governance was expressly mentioned into the UAE Companies Law. And that was definitely the first time where the law described governance as a framework of controls and procedures designed to keep companies disciplined and clarify the roles of the board and management, protect shareholders, and also ensure fair treatment of stakeholders.
And all this might sound very obvious and familiar now, but at the time, that was a real shift, wasn't it?
Yeah, it was quite pioneering, like definitely, absolutely. Like it was basically the law that laid the foundation for everything that has followed, particularly for what concerns public joint stock companies, also because it gave the Capital Market Authority a clear mandate to develop more detailed governance rules over the time.
So speaking about capital markets, many of our listeners will be involved in working for perhaps listed companies, or perhaps they're running a business that is thinking about an IPO. How did the Capital Market Authority's governance rules develop?
Yeah, I mean, it's also true, right? Every time we speak about governance, immediately thoughts will go to listed entities. So it makes sense for us to cover first listed entities, although later we are going to get also to the private ones because governance concerns everyone. So for what concerns those companies that are listed, a major step came a bit after the 2015 Companies Law. So at the time we were in 2020 when the now called CMA, that at the time was called still ESCA, Securities Commodities Authority, issued a new governance code that replaced the earlier more fragmented rules. So there were different pieces and the new code basically consolidated all together. And the code covered things like board composition, need for specialist committees, internal controls, much more detailed disclosures and so on.
And in practical terms, what did this mean for boards of directors?
So yes, I mean, important elements that, again, Western countries have seen coming earlier, and I think it was a correct adaptation also for this region, is that the boards were expected to be largely non-executive and independent, And then in terms of the committees, companies had to set up audit, nomination, remuneration committees that were made up entirely of non-executive directors. And another element to consider was that there was a very strong focus on compliance, risk management, and transparency, particularly around related party transaction and directors' pay.
And we saw more changes in 2024, didn't we?
Yeah, definitely. And 2024 amendments introduce more flexibility, which I think is a great feature of how legislator acts over here, adapting the law time by time to what the experience of the players are feeding back to the legislator. So this element of flexibility, how it comes up. So boards still needed to have a majority of non-executive directors, but only 1/3 now have to be independent rather than the whole majority. So it's easier also to appoint them, and there is a bit like consider the choice. This was really a very effective change to make to the rule. And the new amendments also tightened up how vacancies are filled. So expanded definitions of related parties and also introduced qualification requirements for board secretaries.
And then finally, to sort of round it off, what happened in 2025?
Quite interesting. I would say, 2025 literally is like the other day, right? So it was quite a specific change. And yeah, our assumption as always is there has been cases in the market that have prompted this. There has been requests coming from the player. So what is the change that was implemented in 2025? Basically, the amendment allowed the roles of chairman and CEO to be combined, but with certain safeguards, right? So the company's article have to allow this, first of all. Shareholders need to approve this, and at least 75% of the board must be independent. So this gives you the sense that there needs to be so much safeguard around it that then allows that level of combination of roles to avoid conflict of interest, to avoid that this impacts negatively of the corporate governance. And all committees must still be made of independent directors, and this combined role needs to be also reviewed year by year. So it's really just to give this option if people want to adopt it, but at the same time, it needs to be balanced with some protections, right? For shareholders, for all those that are stakeholders in these companies.
Well, that raises an interesting question, doesn't it? Why would a company choose to combine the role of chairman and CEO, given all these extra independence requirements that are involved?
Well, for some businesses, like particularly we see a lot of this type of companies here in the region, right? Those that are founder-led or family-influenced companies. What it happens, like basically this really makes decision-making faster and definitely much more coherent. But of course, as always, like there is an upside, there might be also a downside because given the level of safeguards and structure that people need to put in place, it comes with a cost. So it's like it might have an impact financially and also in terms of governance complexity. So it's not a light decision to take, but it means that there are real motivation behind it.
Yeah, absolutely.
As we said at the beginning of our podcast, governance definitely isn't just about listed companies. So we need to a bit dig in further for this aspect adapted to private joint stock companies and LLCs.
Yeah, so on private companies, there's been a few developments over the years worth highlighting. So firstly, there was a ministerial resolution in 2016, so after the 2015 Companies Law came into force. And that resolution basically extended a sort of more onerous governance regime to LLCs and similar liability rules for managers of LLCs. So in practice, this means that really the manager of an LLC is subject to very similar fundamental duties and liabilities as the director of a public company.
Yeah, which means that people that are acting in companies that are not listed, like the managers that can be directors, general managers, and so on, they shouldn't assume by any means that they're operating in a lighter touch environment because still governance rules apply.
Absolutely. They still have statutory legal duties of due care and loyalty to the company that they're representing. The law also gave minority shareholders some stronger rights. For example, the ability to insist upon a general assembly meeting of all the shareholders, and the ability to challenge in the court a decision of, say, the managers that they feel is prejudicial and not in the best interests of the company.
Yeah, and I think definitely like family-owned LLC is a good example, right? So if two family managers disagree and the business is stuck, minority shareholders now have clearer tools to force discussions or court oversight, which is an option.
Yes, absolutely. And another development came in 2022 with some quite specific rules, predominantly aimed at sole shareholder LLCs. Now, of course, these are becoming more and more common since the UAE relaxed its foreign ownership restrictions for many of the sectors onshore. So you quite often now have for example, foreign investor wholly owning a subsidiary here in the UAE.
Yeah, but which doesn't mean, of course, that if there is only one shareholder, then there is no matter of governance, because effectively this was what was happening also in the past, like founder-led company or a company that had like one major entity as its owner was sometimes treated that it was like part of the same company, which is not the case. Like literally when there is a sole shareholder LLC, governance might be sometimes even more important, because really you need to make sure that that company is running as an independent basis and has got the structure to be balanced and have its own corporate benefit as a priority, right? So definitely for our clients, important to keep in mind that one shareholder entities are subject to governance rules as much as those that are not one shareholder.
Yes, absolutely. So the rules do still require, for example, proper record keeping, independent audit of the accounts, formal approval processes for major transactions, clear rules about distribution of profit. And there are also in the regulations some continuity provisions so the company can continue to operate if the shareholder were to pass away.
And I have the typical question that we get asked at every training we run, which is, I think you can guess it already, which is if the rules applies also to the free zones.
Yeah, so the commercial companies law is predominantly applicable in the onshore environment. But of course, we have many free zones here in the UAE, and they do have their own company law regulations which apply to companies that are established in those free zones. And those rules typically include essentially the same types of governance provisions around duties owed by directors to the company. So the direction of travel is really the same, whether you're acting sort of onshore or in one of the more than 45 free zones of the UAE.
Yeah. Yeah, and maybe another issue that I think it can be of interest for our audience is the board or the management deadlock, because, and this is something that we discuss very thoroughly, right, when it comes to shareholders agreement, and particularly it comes relevant when there are JVs and so on. So maybe we can cover a bit like how the law deals with these aspects now.
Yeah, so the 2021 Companies Law introduced some more specific rules around continuity. So for example, if a manager resigns and nothing is done about it, the resignation will automatically by law become effective after 30 days, and the company is then required to appoint a replacement. And similarly, if you have a board of managers or a board of directors for an onshore LLC, and their sort of period of tenure expires, if the shareholders don't appoint new directors, the existing board can continue for a limited period of 6 months after expiry of their term, which gives shareholders a bit of time to agree on the next steps.
You know that I don't like to make your life easy. So what happens if the shareholders instead don't agree?
So yeah, if the shareholders are still deadlocked after this 6-month period, what happens? Well, the law now clearly expressly provides that the licensing authority. So here in Dubai, that would be the Department of Economy and Tourism, can actually step in itself and appoint a board on an interim basis. And the 2025 amendments have strengthened this power even further. So originally the law in 21 allowed the DET, for example, to appoint just the shareholders themselves to the board. But of course, if they're in a disagreement, dispute, deadlock, that might not be that useful. In fact, it's not going to be useful at all. So the 2025 changes actually now allow the authority to appoint independent third parties to act as directors. And that can really help by just having a body in place that can take day-to-day management decisions and perhaps help break any deadlock or stalemate.
Yeah, it's a kind of a safety net. And yeah, generally clients, maybe they want to rely on it.
It's generally better to plan ahead. So it's great that the law has these tools, but particularly where you have a family business or a closely held company, it's much better to think ahead, agree on succession and decision-making mechanisms from the outset.
Yeah, which is something that resonates a lot, right? Like these are the typical conversation that we tend to have with our clients when they come to us, of like planning ahead can really help business resilience, business continuity, and what's going to happen, like the challenges in the future. So yeah, definitely a very good tip.
So before we wrap up, let's look forward. What themes, Roshanak, do we think clients should be thinking about?
Give me a minute, I take my crystal ball. No, I'm kidding. Like definitely there are a number of topics that are quite predictable. So definitely on our side, I think you would agree that we expect continuous focus on board independence and diversity. And when we speak diversity, we don't just speak about gender, but also skills, experience, and with resilience in governance practices becoming even more critical amid current challenges, it's so important to have people that can bring different backgrounds, different knowledge, different know-how, and act together and bring that element of intersection and complexity that decisions are now requiring in terms of actions, right? Another area that I think definitely we can expect to have a lot of attention is ESG. And we know that is becoming much more central also for those companies, for example, acting in energy sector and renewables that are seeking international investment, where ESG is so important.
And another big area, I guess, would be digital. The world is online. We're grappling with AI, etc. That's another big issue, isn't it, Rosh?
Yeah, and I think that already we had a heads up, right, during COVID time in 2020 and so on. So even us, like we are recording this this podcast online. So yeah, definitely things like remote meetings, e-voting, digital board packs, cybersecurity oversight, they're becoming part of a good governance practice, which is not only anymore an optional element or an add-on, but it's really focused and central.
And what about family businesses, which of course form a huge part of the business world here in the UAE?
Yeah, and we think also it's going to continue, right? So definitely family governance will remain critical. Family councils, shareholders agreements, clear succession plans are becoming really essential. More than becoming, I think, are essential, really. Especially, I guess, now that the law provides also much more formal continuity mechanism. I think that this is an area where we're going to see increased focus for the time being.
And all of this ties into a broader message, doesn't it?
Yeah, I like this part because it's always like a good memento mori, which is that there's good governance definitely isn't about ticking boxes, right? It's really about concept and substance. So it's all about building trust, managing risk, and creating long-term value. So companies that invest in strong governance framework are usually, or almost certainly, I would say, better placed to attract investment and also navigate change and uncertainty. So good governance means good business and long-term future. So As we said, these amendments continue to reshape the UAE's corporate environment. They continue to drive transformation, resilience for business operations, governance, and investment strategy.
And we expect further clarity and alignment from the regulators as they refine the framework and aiming to support both local and also international investors into the country.
And we really hope that this is going to be helpful for our audience, and you're going to find this useful as input on how governance can be used for your businesses. But if you would like to discuss further with us, as I said, like, we're very passionate about this topic, so we are happy to discuss the developments and how they can impact your business or investment strategy. So by all means, feel free to reach out to the corporate team across Middle East and Africa.
And we look forward very much to having our colleagues share additional insights in the upcoming conversations. Thanks very much.
Thanks a lot. Thanks, Rebecca, too.